Welcome to the VirgilHR Federal Legal Update Recap. This is the time of year when charitable activities ramp up, and workplace volunteer programs can be great for employee engagement and brand reputation. At the same time, HR needs to keep labor law requirements in mind to avoid compliance issues. Let's take a look at the potential compliance issues that come with building a workplace volunteer program. We'll start with classification and risk. The Fair Labor Standards Act has strict rules about who qualifies as a volunteer. Disregarding these rules can risk turning a well-intended volunteer into an unpaid employee, which creates legal and financial exposure for your company and the volunteer organization. So, let's run through those FLSA rules. A volunteer is generally not considered an employee under the FLSA if they volunteer freely for public service, religious or humanitarian objectives, and without expecting compensation. Volunteers typically serve part-time and do not displace regular employed workers or do work that would otherwise be done by regular employees. In addition, paid employees of a nonprofit organization cannot volunteer to perform the same type of work that their nonprofit already pays them to do. Importantly, under the FLSA, employees may not volunteer for profit private sector employers. Individuals generally may not volunteer in commercial activities run by a nonprofit, such as a gift shop. Additionally, employers cannot require employees to become volunteers. If participation is mandatory, the employee may be considered an unpaid employee rather than a volunteer. To prevent misunderstandings and mitigate legal exposure, consider training your managers on these classification rules so they can run volunteer programs compliantly. See you next week with more legal updates.